Okay, reminding everybody that this webinar is being recorded so that we can have it available for folks afterwards. And as a reminder, this webinar is being presented as part of the grant from the Department of Justice through the Bureau of Justice Administration through the Upholding the Rule of Law and Wrongful Conviction Review Program. So this webinar is one in a monthly series that we do both for grantees who are under the grant, but also for really anyone who's engaged in post-conviction litigation for potential innocence cases, whether prosecutors and CIUs are thinking about forming CIUs or lawyers or other staff members that are with innocence organizations. So as we get started, I just want to ask everybody to mute yourselves for background noise. If you have questions or things you want to ask as we go along, our general policy is go ahead and speak up, or you can just send it in a chat and we'll make sure that our presenters get it and can address the question. So today we're going to focus in on very kind of, I guess, meat potato kind of issue, which is investigating innocence claims. So I've asked our two presenters here to be with us because they have unique backgrounds that can really help in terms of trying to figure out how are we going to start an investigation, how do I know where to go, where do I get information, how do we approach witnesses, what are some of the bigger issues we need to be involved in. Both the Jims, Jim Trainum and Jim Figorski, come to us with a background in law enforcement. So Jim Trainum was served for 27 years on the Metropolitan Police Department force, about half of those as a homicide detective. When he left the force, he started working in case review, starting with cold cases as homicides to take advantage of DNA testing was coming on the market, but then expanded that to really any homicide, whether there's DNA possibility or more. And he's involved in investigations all around the country, both in terms of actual investigations, but also more as investigating the investigation. So Detective Trainum is an expert at being able to review a police investigation, kind of seeing where there may have been errors in that investigation, where questions may have been raised that weren't addressed.
That bridge when we get to it, period.
Shouldn't have been. Again,
nothing else, comma. We could do a
view.
terminal disposition and convert this to a restitution.
Okay, hold on one second. Okay, got it. And so he has his own form that he uses, and he's called on as an expert for cases all around the country, both by prosecutors and by defense counsel. Jim Figorski similarly has a police officer in Philadelphia, served for 25 years as a police officer, mostly in the narcotics investigation, but worked his way up through the ranks. Also was cross-designated with DEA as an investigator, and is currently an attorney at the Deckert Law Firm, which is based here in Philadelphia. And we'll share that when I started the Pennsylvania Innocence Project, Jim Figorski was quite literally one of the first lawyers who contacted me to volunteer, and he served as a volunteer attorney while working at Deckert. And it was Jim's investigation abilities and just his real knack for understanding how a case works or how it should work that led directly to the exoneration of Sean Thomas, who had served over 27 years for a murder he did not commit. And Jim is the primary reason that Mr. Thomas is now a free man. So I am just so thrilled that you both could be with us today. I am going to hand it over to Mr. Trainum and allow him to take it. Again, any questions that you have, please put in the chat. We'll be sure to do that. The two Jims are going to kind of do this as a bit of a back and forth. Jim Trainum is going to be taking lead, and Jim Figorski is going to be adding on as we go through. So both of you, thank you so much for being here and welcome. We could not be happier to have you.
Sure, thank you. And this will be a little awkward because this is the first time I've done a co-presentation on Zoom. Do you think that you could put Jim's picture up there as well so I can at least see if he's trying to motion to me and vice versa?
I can see you, Jim.
There we go. Okay, perfect. Thank you. Okay, well, what I wanted to do first is kind of give you guys an idea of the background of where we pull all this information from. We're just not making that out of thin air. A lot of it's our personal experience and the experience of other people that we've worked with. A lot of it's also just basic investigations 101. It's the type of work that cops have been supposedly doing, for decades. We relied a lot on the work from sentinel event reviews and the research on investigative failures that we're going to talk more about as this progresses. But also, one of the things that I've done is I've taken classes in the UK on investigative interviewing, but they also teach a series of classes on how to think like a detective, and also they have a whole system on how they do independent reviews of major cases and of wrongful convictions. And just the process that they use is so logical that we've kind of incorporated it in here into our presentation as well. These are the topics that we're going to kind of break down. We're going to talk a little bit about if you're a beginner in this area. We're going to also look at the big picture of reviews, talk about documents and evidence, the preparation, the investigative mindset, and we're going to try to get into the practical steps to give you some ideas as to the nuts and bolts of what we do when we take on a case. For those who are brand new, because I don't know the experience of all of you, I just want to kind of start out here. The point that we want to make is that, you know, there's really nothing new under the sun. A good way to start these things is to start reading other cases involving wrongful convictions. Either the cases that have been written up by the Sentinel Event Reviews. In the UK and Canada, if there's a wrongful conviction, they have a major review of it, nuts and bolts, beginning to end. And those are really, really helpful when it comes to kind of understanding how, because all these cases seem to fit a pattern after a while. And if you study the, 5 or 6 or 7, you kind of start to see what that pattern is. But also looking up the most recent research on things like eyewitness ID, false identifications, informant use, things along that line.
And I'm sorry, just by the way, the informant use has been a key issue in some of our cases as well, including the Sean Thomas case, where the police misused an informant. So you'll see that quite often in some of these cases. You'll see informant misuse. You'll see false confessions, and of course you'll see that overtime is a large motivating factor in some of these cases. That there's officers looking just for overtime, and they get court, or if they go to court, they make overtime. So that's one of their motivations for doing some of the things that they've done. I mean, not much we can do about that, but just keep that in mind. Okay, Jim, sorry.
We're just talking about informants. I was reading some grand jury findings out in LA back in the 1970s, where they did a major investigation on the use of jailhouse informants. And the problems that existed in the 70s still exist today. And like I said, that's why it's good to read stuff from the past, and also what the latest findings are right there. Now, when it comes to, okay, also something else you should probably consider is think about how law enforcement has changed over the years. Like I was talking about the informants in 1970, there's been a lot of research that's been done on their usage and all that, but a lot of organizations and agencies have adapted their policies and procedures in response to the latest research and things like that, especially in the areas of eyewitness identification. The International Association of Chiefs of Police, they have out model policies and things along that line. And something that's really starting to come to light more and more, which it should have come to light a long time ago, is how we deal with the intellectually and developmentally disabled. Believe it or not, they all fall, well, you do know that they all fall under the umbrella of the American with Disabilities Act. And the American Disabilities Act applies to how law enforcement deals with them as suspects, involving interrogations, Miranda, all that sort of stuff. And that's something that really hasn't been touched on, let's say, much recently. But also, you can see where there's been a lot of things that have now been discredited that used to be used a lot in the past, a lot of the training and tactics. Things like, even though those trainings and those things that still used somewhat today, such as the voice stress test that used to be very prevalent back in the 1990s, has pretty much been discontinued now as a modified polygraph. Things like training on satanic crimes, which has pretty much been discredited. So that's just something that you should, if you're getting going, kind of get a feel for what's out there.
By the way, law enforcement has changed regarding interrogations dramatically, in part, at least in Philadelphia, thanks to Marissa Bluestein, who worked with the Philadelphia Police Department to get all interrogations in the homicide division recorded on video. For years, there's no recordings at all that were permitted of any of those interrogations for some reason. I mean, I have my own reasons why I think that's true, but strangely enough, the case clearances after the homicide division adopted the recording techniques dropped from in the 70s to the 30s. So they went from in the high 70% clearance rate range down into the high 30s. And of course, some people are saying they're not happy with that, but I think they're getting a better product in the end because there's going to be fewer people wrongly convicted.
There you go. The next slide doesn't want to play. Hold on. Okay, now we're going to kind of look at the big picture of doing case reviews. We all know the major contributing factors or the major factors of wrongful convictions. And in the past, when we've done reviews, there's been pretty much a narrow focus on those individual causes right there. And when it comes to law enforcement, we like to blame individuals. We like to identify the detective who got the false confession, who may have bundled an eyewitness ID, and kind of put all the focus on them. But what we really haven't done is taken the time to really understand why the detective did what they did at the time, or what is also referred to is why did they think it was a good idea to do what they did at the time.
Yeah, and by the way, during the Sean Thomas case, this is one example of some of the factors that lead to wrongful convictions. Just as one example, when I later after Sean was exonerated and freed, I had the opportunity to sue the city of Philadelphia, and the detectives who had jailed Sean Thomas. And when I deposed them, almost all of them to a person said that they went with their gut feelings on these things. Not one of them ever mentioned any evidence or any physical evidence or scientific evidence that led to their conclusions. Every one of them talked about they had a gut feeling for how this went, and they understood just from looking at the crime scene how this was done and who did it. And strangely enough, we found that in at least 3 cases so far that we've looked at, Willie Veazey being another and Walter Ograd being one as well. As well as another one, James Dennis, who wasn't an actual Innocence case, but he was released later. And the police in those depositions all talked about having gut feelings about who did it. So just be aware that this is how some people operate. They're not looking at evidence; they're just going by their feelings, and they have a great deal of confidence in their feelings and believe they're always right.
And that's exactly why you really start to need to branch out from these individual causes right there and start, like I was saying, looking at the big picture. We've done that in the past. I mean, in this one study, they found all these different contributing factors to false confessions and other causes of wrongful convictions, such as public pressure to close the case, the fact that the suspect was a neighborhood weirdo, things along that line. Now, and we've expanded that. Oh, I'm sorry, just as an example, as to all the different things that can contribute to one root cause. Back in 1994, I got my own false confession case. And if you do a very broad analysis of it, a holistic approach, more or less, there are all these other contributing factors that not only led us to getting that false confession, but also got that false confession into the court system and accepted by the judge, and even the defense attorney at the time believed that, because he believed it was a false confession. So we were all complicit in moving this case so far along. Fortunately, through our investigation, we found an alibi, but she spent several months in jail before we were able to sort all this out.
There are a number of cases all over the country involving false confessions, and I'm sure you've heard about some of the scandals in Chicago and in Brooklyn involving 2 certain detectives, one in Chicago, one in Brooklyn, who've been accused of taking numerous false confessions. Well, Yeah, we have one in Philadelphia too, and he's one of the people who did the Sean Thomas investigation. I won't mention his name, but he has been accused of taking multiple false confessions. And for years, people were saying it and no one believed it until one of them was proven false by DNA. That was the Tony Wright case, right before Sean Thomas was released. And what we found when we looked at this detective was that there were multiple indicators early in his career that he was taking both false confessions and false witness statements from people, that he was coercing them. But nobody understood it because they were all these people had complained in court and to the DA's office and various people, but no defense attorneys knew about it because they were all done in isolation. So one person complains in one courtroom that this is a false confession, and he goes on the stand and said it didn't happen this way, I never said this, and nobody else hears it. And then another person says the same thing in another courtroom. But we were eventually able to get all of these transcripts from back in the early 90s and found out that numerous people had made these complaints about this detective, but nobody knew about it. So one of the things that you might want to look at is whether other people have said that the person who's been accused of eliciting a false confession has done so.
Now, even more recently, there's been a ton of research into all of these contributing causes and how they impact the investigation, the mindset of the investigator, and all of that. And at the very end, there are going to be some links to some literature, mostly this stuff that you see right here, that talks about the role of confirmation bias in wrongful convictions and also other issues that we're going to talk about. One of the things that they've come up with is, you have your primary factor that leads directly to the failure, but there's all of these little secondary factors, like I said, that either promoted or influenced the primary factor that caused the investigative failure or the wrongful conviction right there. And they've kind of broken them down into three sections. One is personal, and organizational, and situational. And we're going to talk about those briefly here. Personal issues, the main one is the investigator falls victim to any of the cognitive biases that are out there, and we're going to talk more about those. The ones on the left those are the most common ones right there. Lack of training or experience, lack of supervision, lack of training of the supervisors, things like that. The rush to judgment, or as some people say, the rush to get it wrong. And one study has shown that all wrongful convictions, it basically boils down to the failure to evaluate evidence properly. And noble cause corruption is something that we're going to talk a little bit more about in just a few minutes. Situational factors, these are kind of things that are outside of the detective's control at the time. A police informant might be a situational factor, and an informant comes in out of the blue and intentionally lies about what they know about the crime or the suspect, things along that line. You don't have a lot of control over them coming forward with the information, but you do have control over how you evaluate it. One of the situational factors I list is TV shows like The First 48. And I use the example of the Miami homicide unit, who was featured on that show. And for those of you who haven't seen it, it's based on the premise that if you don't solve a homicide in the first 48 hours, it's going to be very difficult to solve, which is true because the ones you solve in the first 48 hours, those are the easy ones. That's the domestic, with the guy standing over top of his wife saying, yeah, I killed her, I killed her. Yes, I killed her and I would kill her again. But what they found is, so what they would do is they would follow the detective around and they would have a clock ticking. And if they solved the case within the first 48, then they got to be broadcast on TV. Well, the local newspaper did a review of all the cases that were featured, and they found that a lot of them were being dismissed because of huge problems with the investigation. So what was happening was that there was an artificial timeline put on the investigators because they wanted to be on TV. So they were cutting all kind of corners and pushing all kind of limits just to get on TV. And so there was a lot going wrong. So that's just, like I said, that's one of the things that can cause problems with an investigation, that kind of outside artificial pressure. And then there's the organizational issues, just the emphasis on closing cases. Detectives are judged by stats. Hey, if you want to be in the homicide unit, like Jim was saying, if you want to be in the homicide unit and you want to make all that overtime, you better give me the closures. And unfortunately, you get pressure to close cases quicker than really should be done. And so it's that sort of pressure that can make detectives go off on the wrong path and try to do things quickly and do things the wrong way.
I'm sorry, Jim.
Go ahead.
In Philadelphia, we've had that. In the early 1990s, there's been a spate of cases involving wrongful convictions, and the same group of detectives in the homicide division. And what we found from looking at it was this was the time in Philadelphia where murders were at an all-time high. There were 500 murders in 1990, 400 and something the year after, and there were a number of people who were wrongly convicted at that time. And I think what happened, based on what we saw during our investigation and during the depositions, was that there was tremendous pressure to solve these murders. And detectives who are, I don't know where they, these other departments, what they're paid, but homicide detectives in Philadelphia are the highest paid people in the city. They're paid more than the mayor, they're paid more than the police commissioner because they make so much overtime. And if you're a homicide detective making $250,000 a year or more sometimes, and somebody tells you, you better solve these murders or you're going to be back in a division making $75,000, you're going to solve the murder. You might not get the right person, but somebody's going to jail. And I hate to say it that way, but that's a fact. And that's what we found. And I think there's, if there's a lot of pressure on people to solve murders, I understand that there's a need to solve them, but I think some of these things are the result.
And one of the things I do want to bring up is when we're talking about this, especially when I've talked to other law enforcement agencies, it almost sounds, it can be interpreted that we're cop bashing, which we're really not.
Not at all.
And what we're trying to do is make you aware of a lot of the different outside influences that can be leading detectives to make the wrong decision, which they think is the right one at the time. But by you understanding this, by you looking for this, by you seeing this, and by you using it as part of your review, what you're doing is you're letting them know that you understand what they were going through at the time. And it might ease some of the defensiveness that comes natural when a detective is told that their case might have resulted in a wrongful conviction, and kind of help them get over that hump to help you with the review process right there.
Right. And I should point out also that of those people in the homicide division in the early 1990s, there were maybe 100 people. Only 6 or 7 of those people has ever been accused of misconduct. So it was a small number of people who were doing the bad acts.
Now we're going to talk about these topics a lot, and I just want to kind of get some definitions out there on the table. We're going to talk about tunnel vision and confirmation bias. And the research that I was talking about pretty much calls tunnel vision a premature focus on a theory or a specific individual as a suspect. And but confirmation bias is a little bit different, is that once you develop a suspect, you then only seek the evidence that confirms your theory, and you're not accepting of evidence that might contradict your theory. And in fact, you might end up suppressing it, misinterpreting it, things along that line. And like it mentions up here, in all of these cases that were studied in this research program, confirmation bias was present throughout the entire investigation. And this is an interesting concept, noble cause corruption. It's basically the detective is going to do the wrong thing for what they think is the right reason. And there's a lot of pressure. I mean, I think Jim's felt it. I felt it coming up through the ranks, and also, especially very early, let's say early on in our career, because it can be part of the culture of the organization too. You're out there to get the bad guy, that sort of thing. And so this can be behind a lot of things, or a lot of problems that you may see in your cases, such as lack of documentation, selective memory during testimony. Jim was talking about videotaping. I tell a story about, how back before all these agencies videotaped all these cases that I reviewed time and time and time again, there was no videotape, just the testimony of the detectives. And almost every single time they would testify about how they would go into the interrogation room and sit down and say, tell us what happened. And 3 hours later, they would walk out with a 4 or 5 page confession that they typed out with 2 fingers as the suspect just broke down crying and said, I just want to get it off my chest. Well, it's funny because, when videotaping was first being, promoted, all these detectives were saying, we'll never get another confession. And it turns out that they were right, because once videotaping started, you never saw another confession like I just talked about. They just didn't happen. And so, sometimes it is just so obvious that they know the games to play. They know exactly how to answer questions. And they're doing it because they feel that they got the right guy and they do not, want to slip up and let him get out of the grass because of some slimy defense attorney. That's the way that they look at it. And that's where you get most of your Brady violations. Prosecutors are blamed all the time for Brady violations, but the Brady violations actually begin with the detective.
And we found that out when we saw some of the homicide files in these cases, where we found things that were never turned over that were pretty key. But going along with noble cause corruption is the idea of the thin blue line. And as Jim said earlier, we're not trying to bash cops. I still consider myself a cop. I always will be. All my friends are still police, either retired or active. I think Marissa Bluestein's the only lawyer I know who's my friend. We're still friends with all cops, and I know how they think because we talk about it all the time, and I argue with them because I used to feel the same way. That we have some kind of a unique view of society because we deal with the public every day, and we know, what's deep in people's hearts, and that's part of this noble cause corruption. We know that this guy might not have done this crime, but he's done other ones. And we've heard that. I've had my friends say that about Sean Thomas and Willie Veazey, 2 of the people who I helped to get out of prison along with Marissa. And I'll say, what do you think about this case? Well, he didn't do this one, but I'm sure he did other things he got away with. And that's one of the ideas that, we can't change. It's just, the way the culture is, but it's something you should all be aware of when you're looking at a case of, maybe a person's innocent, that this is the idea that people have, particularly in law enforcement, and it's not an evil thing. It's just an idea where they've all worked together for so long, and they all depend on each other, and they start to think that they know society more than you do, and they know what has to be done. And if it's an ugly thing, then so be it. But the ends justify the means, and that's what I think Jim means by the ends-based investigation culture. So,
yeah, and sometimes this one thing that I've realized is, and this is something prosecutors you can help your detectives with, is we don't have a good understanding of what Brady actually is and what our legal and moral and ethical obligations are when it comes to Brady. Because I can give you situations where police officials have publicly talked about concealing evidence from the public because they didn't want to muddy up cases. That was one of the reasons that was given once it was being broadcast live on TV. A high-ranking police official said, we don't want to videotape because if they give multiple statements, we got to turn all that over.
right.
The only reason he would be saying that is because he doesn't understand that, yeah, you got to turn all that over. And what you're talking about is encouraging your people to commit a violation of the law. So I think that's a lot of it. We just don't understand it. We're not trained in it. And I think that's a big part of what's missing from our training. So
when I was a police officer in the mid '80s in narcotics, we were ordered to destroy Brady information. We were, by the higher ups, because they had this idea, and they still do. And maybe some of us here have it, that defense attorneys are, quote, the enemy, unquote, and we're not going to give the enemy anything that he can use. And that's literally what we were told. Get rid of any handwritten notes, any memos. Don't have anything in your file that can be used to free this guy. So I don't know if it's as bad now, but that was the mentality at the time. And I haven't been on the job in 14 years, but I wouldn't doubt that there's still some of that there.
So let's go and move on to the first step. And like I said, a lot of this stuff is kind of like common sense, but it's like the, them printing the warning on the hot cup of coffee, warning contents are hot, it sometimes needs to be reiterated because we sometimes forget some of the basic stuff right there. Now, just getting the documents together, getting everything together, it's a lot easier for the prosecutors in the group here because they typically have a lot freer access to stuff. People are typically much more cooperative with them in getting stuff along that line. But one of the things that your file is probably not going to be complete. There's going to be a lot of stuff missing out of there. A lot of detectives have their own personal files. They don't turn everything over unless even in some open discovery states. I know that officers will sometimes maintain personal notes, things along that line, or documents that they don't want to release. A lot of times within an agency, there might be multiple units where those files are located. Like they might have some documents in the evidence file that aren't in the detective's file. Same with outside agencies. So there's all these different places where you can go. And one of the things that we did when we were doing our big case review is we would actually go to the original case detective. And in one major case, we'd go, this reporter was going in front of us. He would go knock on the door. I want to talk to you about this unsolved case. They would say, yeah, come on in. And by the way, would you like to see my file? And they had all kinds of stuff in their files at home right there. But something else that you're going to want to pull up as well is look for the media accounts during that time. Because one, you're going to want to look for statements that were being made by law enforcement, but also you're going to want to look for what we call holdback information. Because a lot of detectives, when it comes to witness statements and confessions, they're going to say that time-honored statement, the suspect only knew things that only the true perpetrator would have known. And a lot of times that's not true because it was in the media accounts. And that's the only way that you can find out. Go back and do a search, get the media account so that you know that everything that was out there in the public during that time period.
As far as the case files go, in one case, the Sean Thomas case, there were several missing files. And it was more of a problem for us than it would be for most people here, because you're probably going to have access or better access to police files than we did. We couldn't get them. We couldn't ask for them. We had no discovery in the post-conviction forum. But we did go and try to find Sean Thomas's juvenile file. Sean was a juvenile at the time of the murder. He was 16. He'd been arrested the day before the murder. And at the time of the murder, he was making his initial appearance in juvenile court. And we couldn't prove that because Sean's entire file was gone from juvenile court. There was nothing there anymore. So it made it much more difficult to prove Sean's innocence without that. And we had to reconstruct things and bring people in from juvenile court who had worked there at the time to show us what should be there and how we could prove that Sean was there. But as far as the homicide file is concerned, we never had access to that until after the case was over and we got it in civil discovery. But the homicide files in all the cases that Marissa and I have been involved in, and I think she would agree with me, have been the key to these things because there's so much there that we found that that was hidden, and it actually lays out the way the investigation went. And particularly handwritten notes are gold. And in every case that we've looked at so far, some of them are difficult to read and they're hard, they're hard to decipher, but do your best because they seem to lay out what's going on behind the scenes of the crime. Other information the police are getting about who committed the murder. In the case of Sean Thomas, we found that the detectives knew that Sean Thomas was at the Youth Study Center on the day of the murder, based on their own handwritten notes of their investigation. In the Willie Beasley case, we found that the main eyewitness had made multiple statements to the police that were conflicting with what she said in her official statement, and that was never turned over. So always be mindful of those handwritten notes. They're gold.
Yeah, and I just, since you said my name 3 times, I appear. And just to point out that sometimes those notes are on tiny little index cards.
Yeah.
So very often police will want to scan the file for you or to copy it for you. We very highly recommend that you actually physically go look at the file, because those little cards often don't get scanned or copied over. And sometimes, quite literally, we've had cases that turn on tiny handwritten notes that would not have been turned over if they had done the copying for us.
In the case of the Sean Thomas file, they were written on sticky notes that weren't even copied. They were stuck to other documents, and we didn't see them until we actually asked to see the file physically and go through it, because they didn't copy that. And what we got was only a partial picture of what was in the file. So always look through the original file.
I actually helped, I was consulted by an author who's an archivist and researcher who was talking about researching cold cases, the different research techniques for cold case detectives. And one of the things that she brought up, which I have found to be true, is if you can get your hands on the original file, just the order in which some of the reports are placed or some of the notes are placed can sometimes be very telling, very, very, very useful. It's like you're an archaeologist going through the different layers, and where something is in that layer might be something that's very significant for you later on. So there's clues everywhere. You just don't know where they are until you start looking for them right there. When you finally do start going through your documents and all that, one of the things that I like to look for is clues as to what should be there, but isn't. So, because a lot of times there's reference to maybe a statement in the testimony, but you don't have a copy of that statement. Things along that line. This one case I'm working right now involves a whole bunch of witness statements that are referred to, like I said, in the court testimony, but they're anywhere near the actual homicide case file itself. And it will help if you know how your agency documents things. So you really should have a good idea, or have somebody you can talk to about how things were done back in the day versus how things are done now. Because documentation, how they handle paperwork, how they store paperwork changes over the years, and that will help you figure out what you're missing, where things might be, and things along that line right there. Another thing is the physical evidence. Is it even available whatsoever? Places that I have found evidence when I've gone to my evidence warehouse, and I've been told 15 times that it wasn't there, and then the 16th time they were able to find something. But sometimes the laboratory would keep samples. We found samples back in the 70s and 80s. Our medical examiner would do a sex kit on a murder victim, take the slides and swab them, take the swabs and put them on a slide, look at them and say, yeah, there's sperm cells there. They would send the kit on for testing, but then they would put the slides into the autopsy file. And we were able to find, there was one case that in particular where an exoneration occurred because of that slide in that one file. Like I said, detectives have evidence in their attic. In one case we were reviewing, I actually had an intern who was going through this murder case file, and I heard her scream. And when I looked up, the murder weapon was in a plastic bag, had dropped out of the file onto the floor right there. One of the things that I like to do is I like to create spreadsheets. I'm a visual person. And so when I lay stuff out, that I know that item number 1 that was recovered from the scene is item number Q5 in the laboratory report, and exactly where it was found and what was missing and what was done and all of that. And that will help you also later on when you're doing your crime scene analysis, which we're going to talk about in a bit. And this here is just a sample, a brief sample of an evidence chart from an old case. And like I said, when you chart this stuff out, it also helps people who come behind you who have to look at this to see exactly, it just condenses the information for them, and they can see at a glance what's been done and what hasn't been done.
And Jim, we have a question from Lisa Kavanaugh. She
Yep.
says, I've seen numerous examples of police departments and homicide units refusing to provide access to their files without a court order, not only when the request comes from an innocence organization, but also when it comes from a conviction integrity unit. Do you have any advice about strategies to overcome that resistance without litigation? I can just, I mean, first,
Yeah.
I can say that I was lucky in the Sean Thomas case because we didn't have discovery. We didn't have any kind of discovery order, but I knew people in the police department and went to them and asked if there were ever any scientific reports that were, or that had been prepared in that case, because there were never any disclosed. And sure enough, they had done scientific testing and hadn't disclosed it. And that was a Brady violation that we were able to get back into court on. But that was just luck that I happened to know the people in the police department and they willingly handed it over. What they do when when they decide to make you litigate, sadly, you're either going to have to litigate or find somebody who you have a good relationship, possibly in that department, to try to work it out. That's my opinion.
Never, like I said, I'm just shocked that a CIE would have a problem getting something from a police department itself. I just think that's outrageous to begin with. But yeah. I do know, like, when innocence organizations and the Public Defender Service would FOIA information from my agency, because I handled all the FOIAs during the time that I was running this review project. I know that certain people, if they didn't word something a certain way, then they felt like they had a loophole that they could deny them the information. Or if you didn't include certain numbers and all of that, that's where you really need to know, try to find out from the agency where they keep this documentation. Like, if you're going to FOIA the evidence reports, you want to go through this unit and not this unit. You want to know, all the different numbers that you need to include, like the report number, the homicide case number, the mobile crime file number, all that kind of stuff, because that's where they're going to get you. They don't want to play to begin with, a lot of these folks. Some because they're malicious, but some because they're just lazy and they don't want to go look for this stuff. So you really need to have, to educate yourself as much as possible on the wording that's used in order to properly FOIA stuff and get it.
Right. I don't think I have to say this, to you people, because you already know it, but you're going to be in a very difficult job where some people in law enforcement are going to see you as not their friends, and they will resist you. And I think your job is sort of akin to being in internal affairs, where you're going to be doing investigations on people who might not like to be second guessed. So you're definitely going to make some enemies, and you're going to, I don't know, maybe not, maybe they'll accept you, but I would think some people will resent it and they will resist you. So overcoming that's going to be a big challenge. And I think you might have to wind up in litigation in some of those things.
Next step, we're going to talk about the investigative mindset. And, basically this is a type of mindset that I like to have when I start looking at any case, is that, even if the attorney comes to me and says, this is a, really, really bad wrongful conviction, we know it is and all that, I'm not out to prove that. I'm not out to prove or disprove anything, and nor should you be. You're going in there with a fresh look, fresh mind. You're going in there to test that original theory and see if there's evidence there to support that original theory. And like I said, I talked earlier about the UK and how they train detectives and how they do their case reviews, but this is exactly what they say, that, this is the mindset that you should have. You challenge every single thing in the case file, and you just assume nothing to be true until it's proven to be true right there. And so you're going in there constantly questioning every single assumption, every single witness statement. You want to be able to show that it's reliable and accurate and based on the evidence and not on somebody's personal opinion right there. Right. There's questions that you should always be asking, not only of yourself, not only of the case, but also of yourself. One is, how do we know what we think we know? Is there documentation to support it? Because in a lot of cases, sometimes a rumor or a gut hunch takes on a life of its own and it becomes a fact. one of the things that I'll mention probably again later is that when I'm doing the documentation, when I'm doing a timeline on a case, every single statement I put in there is cited back to a document. So we know for sure that the victim was shot 3 times because the autopsy report says shot 3 times, that sort of thing. You know, a lot of times you'll get that catchphrase, like I mentioned before, you know, how do you know that the confession is reliable? Oh, because they knew things that only the killer would have known. Well, how do we know that? How do we know that it came from them and not from some sort of contamination, things like that? When you see things that are done, ask why was it done? And if it wasn't done, why was it not done? Just as an example of things that are not done is I have a couple of cases I've worked where the suspect is being interviewed, they're given a confession, it's not on videotape, it's being typed up, but they never asked and these were murders that were done in the house, nobody's, you know, saw the victim until their body was found, that sort of thing. They were, you know, very private murders, but nobody asked the suspect what was the victim wearing. And that would be a great piece of corroboration if they could tell you, but they didn't ask. Why wasn't that asked? So all these things, but like I said, that first question should apply to you, because when you start saying this, this, and this, you need to be able to answer that question for other people as well.
So just from my own experience too, if you know, please look at whether a confession, if you do have a confession case, whether the confession comports with the physical evidence, with the crime scene, with the autopsy report. And even though eyewitness reports can often be wrong, what do the eyewitnesses say and what does the confession say? There's been a series of cases in Philadelphia involving, as I said, the same detective, where he took numerous confessions from people that did not comport with what the eyewitnesses said, had totally different facts in it, and named people repeatedly as co-conspirators who could not have committed the crime. And yet every one of these people who supposedly confessed went to prison for life or wound up on death row. And nobody questioned why that confession read the way it did for many years. So just be aware of things, of false confessions having false facts in them.
And also, since, you know, the thing is, we can fall victim to confirmation bias during these case reviews, just like anybody else. You know, the reports, the way that they're written to support a certain theory a lot of times. They're framed that way. So we have to look for alternative explanations. And we can go down these rabbit holes just as easily as anybody else can. So that's why I always like to have somebody to play my devil's advocate, somebody who has a different viewpoint. If you're a prosecutor, have somebody with the defense background. You know, look at it. You just argue it back and forth. That's the best way to do it as a team effort right there. We're not going to move into some of the practical steps, the ABC stuff that we've come up with, other people have come up with when it comes to doing these reviews. And the very first thing that I really encourage a lot, you know, just absolutely a bare bones necessity, are timelines. You need a timeline of both the crime itself and also the investigation. And it can be in a spreadsheet like this, it can be in a narrative form, whatever you're comfortable with. But you need to be able to put stuff in chronological order. Because what it's going to do is it's going to allow you to take all these different reports and put them together into one narrative so that you can see what everybody's doing, you know, throughout the entire case. Of course, you got to cite everything back. And one of the things is the best thing about this for me is that when you're taking all these handwritten notes and little bits and pieces of paper there and put it into this, it makes it searchable. Because, you know, 6 months from now, you're not going to remember this fact, but if you can search it, you know, based on a word search or whatnot, it's going to save you a lot of time, and also people coming behind you a lot of time as well. When I talk about crime, you know, the crime timeline and scene analysis, the crime scene analysis is really the crux of what you're doing right there. Because once you've determined a good crime scene analysis, once you determine what you really know and what you think you know, like I said, you know that the suspect was shot 3 times because there's 3 bullet holes in him. You can use that information to test the theory, to evaluate witnesses, to evaluate confessions, things along that line. That's what we as cops do. I mean, we're supposed to get a good crime scene analysis. And then if a witness comes in telling you, well, I know who did it, this is what they did. And if it doesn't match, you know there's a problem right there. The problem is that, to be honest with you, we're really bad at this. We don't really spend a lot of time thinking about doing a good crime scene analysis. And just as an example, I took a crime scene analysis school in Florida for seasoned homicide detectives. I was the youngest one there at the time. And the guy had several rooms set up where he had different crime scenes. And one of them was a shotgun murder. And so we were going in there and we were trying to read the blood spatter and all that kind of stuff. We were coming up with this theory and that theory. And the instructor kept laughing at us. And he says, okay, let's kind of figure this out. He took the biggest guy and stood him up, and the smallest guy in the class and stood him up and said, okay, I'm going to stand here with this shotgun. I'm going to blow him away, and I'm going to blow him away. How far is the big guy going to get pushed back versus the small guy? And we're going, well, the small guy, he doesn't have a lot of weight. He's going to get blown against the wall. And he keeps laughing at us. He says, like, I could do any of that stuff. And basically, he says that we learned our physics through Roadrunner cartoons. And that's how we're applying it to the crime scene. And he showed us these movies or these film clips of people actually getting shot, and they just drop straight down. So that's the thing. You need to, you don't trust the original detective. You're going to have to like evaluate it yourself, or have other people come in and help you evaluate it. And that's when it comes to updating it. That's my point. Is the original interpretation still valid? Because of the experience of the detectives, failure to consider alternatives. It's a more important change in the science. You know, hair and fiber, arson, sudden infant death syndrome. All of these things have undergone a lot of change over the last couple of decades. And so the original interpretations may no longer be valid whatsoever. When it comes to investigative timelines, it's going to help you determine what information was known to whom and when. That's going to help you with your witness interviews. The most important thing it's going to help you know is when critical decisions were made and what they were based on. And the most critical decision is when that investigation switches from the detectives following the evidence to the detectives focusing in on a suspect, because that's the time when confirmation bias is the most dangerous. Now, you know, the thing about it is that has to occur eventually. You have to switch from evidence, the suspect based. And we'll talk a little bit more about things to look at in just one second. But with a timeline, what it can also do, it becomes a test for confirmation bias. One of the things that they do in the UK, like I had mentioned, is that they'll take the order in which the evidence comes in, which led to a decision. And then they'll look at the evidence that comes in later, and they'll switch the order around. And then they'll say, okay, based on this new order, would this decision have been the same? And if it wouldn't have been, then there's evidence there that confirmation bias is impacting the investigation, because evidence should not be interpreted based on the way it becomes available in an investigation. So that's something that I've used myself. It has been pretty successful in identifying when that sort of adverse influence might be impacting your case.
I think that's what's so great about using the timeline too, Jim, in that when you look at the actual physical timeline, you can see things right up front. When was this person first identified as a suspect? Why was he first identified as a suspect? Did the eyewitness statements change over time? At what point did they change, and what result then happened due to that change? So it's the timeline's really a great benefit for just looking very quickly and seeing how the investigation went and when these key decisions were made.
And like I said, yes, I began talking about the switch from the suspect base to an evidence base. And, that has to happen with any investigation. And, the thing about it is we get the wrong person as a suspect more than you would like to think. And that's natural because investigations are very, very messy things. You got information coming in piecemeal, it's coming in quickly, it might not always be accurate, but it's supposed to be self-correcting. As you get new information, you're supposed to reevaluate who your original suspect is and then move on to the new one. But a lot of times we get locked in, and through confirmation bias, we don't properly evaluate the new suspect. So in looking at this key decision point, these are the things that you kind of want to look for to see why that suspect was identified and, you know, on what basis right there. You know, some of the red flags that I like to look for when it comes to suspect identification is, like Jim was saying, the lack of evidence. It's based on a gut feeling. Also, sometimes you'll see detectives overusing polygraphs or interrogation. What they'll do is they'll rule people in and out based simply on the polygraph. They'll just haul everybody in and polygraph them. Or they'll get the usual suspects and get subjected to an interrogation just to see what kind of flex they have. And we call that basically investigation by polygraph. And it's really a bad way because you're going to miss out on good suspects and you're going to focus in on the wrong ones way too often right there. And one of the things that contributes to this problem of focusing on the wrong guy is actually the training that we receive. Because basically every single US interrogation school out there that teaches this read technique or this accusatory approach, they also teach this behavioral analysis stuff. And they're trying to convince us that we can tell if somebody's lying, if somebody's being deceptive, or even we can determine who's guilty and who's not based on the way they answer questions, their body language, and all this other stuff. And you may feel that you're pretty good at that as well. Unfortunately, I hate to break it to you, well, the interrogation school teaches that this is 80% accurate right there, which of course leads for a 20% error rate, right, which we won't talk about. But the reality is it's pseudoscience. It's not based on any research whatsoever. The science that is out there says that the best you can do is a flip of the coin. So when you see that this is being used in the investigation to make investigative decisions, that's a red flag that you might want to, you know, kind of proceed with caution right there.
Now, this is very prevalent, by the way, Jim. When we deposed the detectives, the homicide detectives in the Sean Thomas case, each one of them said that they believed that they could tell when a person is lying every time based on their experience. They, you know, one of them called himself a human lie detector. And, you know, I don't believe there's any truth to that. I don't think you do. I think it's just totally, you know, subjective whether you think somebody's lying or not. You can't tell, you can guess. But there are people out there who truly believe that they know when a person's lying based on observing him. So just bear that in mind, that that is how some of these decisions are made.
Now, when it comes to solving crimes, we solve it basically three different ways: evidence, witness, and confessions. When you think of it, you know, two of the three ways involve us talking to people and getting information from them. And actually, the evidence depends on us talking to people to kind of put the stuff into context. So in reality, it's our ability to get that information from people that's the most important thing that detectives do. Unfortunately, it's one of the things that we receive the least training in. And a lot of times we're kind of running by the seat of our pants based on assumptions like we had talked about before. We're human lie detectors. Our interrogation tactics are very benign. They're designed to get to the truth. And we'll know if somebody's lying because they won't be able to tell us those details that are known only to law enforcement or the true perpetrator right there would know. The problem is that all of that is wrong. And one of the things I want to talk about is, you know, even with witness statements, we're taught that if you have a witness or an informant or whomever like that, anybody who you do not think is telling you what you perceive to be the truth, you're supposed to go into interrogation mode. So you actually are taught to use the tactics that have been shown to be coercive, that have been shown to contribute to false confessions against witnesses and other people as well, in order to get them to tell you what you have already determined through your investigation to be the truth right there. When you're looking at the statement, now this is a whole nother lecture, which we don't have, of course, have time to get into. There are basically 3 steps. You're going to evaluate the subject, how they became a witness or a subject. You're going to look at the methods that were used to obtain the information. And more importantly, because, you know, the worst detective using the worst interview or interrogation tactics can actually get a good statement. You're going to want to look at the details that were contained within that statement. And that's a lot of what you're going to spend your time doing when you're looking at, excuse me, at these cases right there. You're going to have to understand, you should understand how contamination occurs, because a lot of detectives don't do it. Just by the way, we're taught we should not use leading questions. But if you look at a lot of these interviewing tactics, they're the most commonly used questions in there. I'm not going to go over all of these. You're going to have some literature and stuff. If you're interested in this, you can always email me afterwards. I'll send you some stuff on this. But a lot of times, the interrogation or the interview is like we're unintentionally feeding them little bits and pieces of information that they're regurgitating back to us. And when it comes to evaluating a statement, you're going to want to know, are they getting that information because they were there and they saw it, or is it being fed to them unintentionally by the investigator right there? Now, when I started looking at statements and confessions originally, what I would often do is I would look at the crime scene and get a good idea with the crime scene, and then I would compare, you know, the statement to the crime scene. But what I did was I kind of switched it around, and I started looking at the confession first, or in the interrogation, if it was videotaped. And I would say, okay, assuming that this is true, based on what the suspect or the witness is telling me, what would I expect to find at the crime scene? And if it's really off, then that's a red flag. And oftentimes, if you can listen, especially with videotaped ones, if you can listen to the investigator, if you can learn a lot about the crime from what the investigator is telling you, then that's a really good sign that there's a lot of contamination going on. So just kind of a couple things, down and dirty evaluations that you can do. Always look for new information. Every detective, when they're interviewing somebody, suspect or anybody, needs to start looking for information that they did not know earlier. And such as, you know, yeah, I shot the guy and I hid the gun up in the attic, and you go up in the attic and there's the gun, and sure enough, it was the one used to shoot the guy. That is good stuff. That's what you're always looking for. But if it's not there, sometimes you have to ask, okay, what should they have asked? What kind of new information could they have potentially got? And why didn't they ask those questions? But when you do get the details in the statement, like I said, what you need to do is look for potential of contamination. And when it comes to contamination, like I said, you need to look at who's telling the story. Is it the detective or is it the suspect? Because if the suspect is able to give up, or the witness is able to give up all those details, you have to be able to show that it was done without some sort of leading. Now, I'm sorry, Jim, I think you had a comment about the last slide.
Okay. No, I was just going to say, when you look back at these cases and you're looking back at, say, a confession, and you want to see whether a person actually tried to corroborate what's in the confession to prove that it's true, just bear in mind that sometimes they did, and they couldn't corroborate it, but they would go ahead anyway because of their own confirmation bias. And for instance, in the Sean Thomas case, there was a third-party confession where a man confessed falsely to police and said that he had committed the crime, and so did these other people, including Mr. Thomas. When the detectives went out and tried to confirm it, they found that 2 of the people that had been named by this person could not have committed the crime. One was in prison at the time, and another one was living in Ohio, several hundred miles away. And they also found that Mr. Thomas was likely, at juvenile court at the time of the murder and was not at the scene of the murder. But they proceeded anyway because they believed that this confession was true, and they believed that they had the right people based on the rumors that they were hearing from the neighborhood. So this is just a mindset that people have where they believe they're right, and they will not be dissuaded sometimes by even good evidence that there's something wrong. And rather than pause and say, wait a second, we're going to take a better look at this, there's something wrong with our theory, these people just move full steam ahead and went and arrested the people. So
well, part of it is the old belief that nobody would confess to a crime that they didn't commit.
Exactly.
So therefore, it doesn't matter if I told you all the details about the crime, you would never admit, you would never say, yes, I did it, unless you had done it.
It is counterintuitive.
Most people worry about contamination.
Exactly. Most people, think that that's true. In fact, there are DAs to this day who don't believe in, that there's such a thing as a false confession. So
that's a whole nother topic for another presentation. Yeah. So, okay, a false fed fact. This is where your timelines really become helpful in your crime scene analysis, because this is a huge red flag for contamination. It's basically when a detective believes something to be true, and it's concluded in the suspect's confession or it is included in the witness's statement, but it turns out that it's later false or incorrect. Well, that witness or that suspect got it from somewhere, and it had to have come from the detective because it didn't come from the crime scene and it couldn't have come from anybody else. Very simply put. Again, interview charts. I like interview charts. What I do is I break them down, almost line for line, who's saying what. This is just one sample. But a lot of times, especially in videotaped interrogations or audio interrogations, if you put it into a chart form, you can see how the story is developing. You can see what improper tactics were being used. But more importantly, you can see who's bringing up the information first. And you get a better idea how it gets incorporated into the final narrative right there that's acceptable to the detective. But even if and so when you get your statements, just like everything else, you compare statements to statements, multiple statements to each other. If a suspect gives multiple statements over time or a witness, you want to see how they change and why they change, and also statements to evidence. And this is just a sample. This was a non-recorded interrogation or witness statement. And what I was doing was I was comparing the different statements, the details to each other, and then to the physical evidence and to other statements as well. And this, when I put it in chart form or whatever like that, it not only helps me, but also helps other people kind of visualize, what you're saying right there.
And for those who are checking out that, yes, that is from the serial case Adnan Syed.
Yes. And of course, there's always details that don't fit. There's all sorts of ways to examine these, but what you'll find a lot of times, rather than examine, okay, why are these details in there? They're often just explained away. In my case, the suspect gave all this BS, and we just kind of figured out, okay, yeah, she's saying these things. We know it's not true, but she's trying to protect somebody. So that's just how confirmation bias plays into that part right there. And finally, I think one of the most important things you can do is go to the scene. Even if it's no longer there, it's really important, I think, to at least get an idea of the spatial relationships with streets and alleyways and all that sort of stuff. Stand where the witnesses said that they were standing, and can you see what they said that they saw? I remember in one case where we had this long confession of this guy who did this murder in the playground. I took his statement and I went and I walked the route that he said he was going to walk, and it took me to a different playground. It wasn't the playground where the murder occurred. And so many times detectives don't bother to do that. And I think it's one of the most important things that anybody can do right there. Jim,
Just try to reenact the crime too, if possible, particularly if it's a very long and complicated crime. You know, go after the scene and try to reenact it. In at least one of the cases, we were unable to do so. You know, you just couldn't do it the way the prosecution presented it at trial. It could not be reenacted the way they said it happened. And that's the crux of the case. If it couldn't have happened that way, there's something wrong with the investigation. So always go to the scene.
And a lot of times, just kind of a couple closing thoughts. You know, the thing about it is a lot of times these things aren't done because of the pressure that's on the detective. You get a confession and you're sitting there 2 days later trying to go through phone records to corroborate stuff, and your boss comes up to you and says, "What the hell are you doing?" Well, I'm just like, "No, you got other cases to work on. This
Right.
case is closed. You got to move on." Things like that. So yeah, sometimes it's confirmation bias, sometimes it's the rush to judgment, but you know, also sometimes it's just lack of resources and lack of time that can lead to cases really getting off track and resulting in wrongful convictions. And that's something that, like I said, if you come in with that kind of understanding, not only will you see the big picture, but I think you'll get more cooperation from the folks who you're trying to work with. Jim, anything yourself?
No, I totally agree. One of the things that I wanted to add to what you said about, you know, trying to corroborate and confirm things was in several of these confessions in Philadelphia, these false confessions, we couldn't figure out why people were giving totally wrong facts. And if this was a false confession, why not make it right?
Mm-hmm.
Why not make, you know, the confession, you know, conform to the crime? And when we finally went out and spoke to the people who made these false confessions, they all said the same thing. What they said was the detective didn't beat them into a confession. He beat them into signing a confession. And what he would do is he would write something out based on what they were saying, and it was a mix of truth and lies. So for instance, he would say, "Look, I don't know who did this crime. I have no idea." "Well, what did you hear about it?" "Well, I heard it was Jim Trainum. And Jim Trainum was driving a blue car, and he had he had this and he had that." Well, this guy would be writing it out, and these people thought that they were making a statement, you know, based on what they heard, and he would flip it into, he said this. He said that he went out and robbed and murdered this person in a blue car using a .38 caliber revolver, and they would sign it. And all these people said the same thing. So that was a strange thing that really took years to clear up, and nobody believed that these were false confessions because, strangely enough, they weren't true. They didn't match the crime scene or the witnesses. But what these people said was this was the rumor that they heard that they imparted to the detective, who flipped it around and made it a confession.
And the other point that I would like to bring up on the flip side is that they're kind of an anomaly as well. Most cases that I've worked, the detective had no intention of getting a false confession whatsoever. They really honestly believed that that person committed the crime. And they also understood that they weren't supposed to really contaminate. There were certain things that they weren't supposed to do. They weren't supposed to totally feed them the information, but they fed them enough, maybe out of frustration during the long interrogation, that you should be able to tell me this stuff, but you're not. But there's enough true facts in there that they kind of accept it. They accept the final confession because, like I said, you're not going to confess unless it was true. And the other stuff they just explained away. So that's why a lot of false confessions aren't perfect, because it wasn't the intent to get a false confession. They got what they thought was a good confession, and they did the best job that they thought they could do to do that. It's just that they didn't do the follow-up, and they didn't recognize the traps that they had fallen into.
In at least two of these cases, by the way, there were at least two witnesses, one being a surviving victim who was shot and survived, and another being a person who had a conversation with the person who did the murder. Two separate cases in which, after the confession was made, the detectives never showed a photograph of the person who confessed to that surviving witness, or to the person who had the conversation with the gunman. And if I'm going back and looking at this, I have to ask why. If you have a confession from a person who says, "I did this," why wouldn't you show a photograph to the person who saw this person face to face and can identify him? And that, to me, shows that they knew that there was a problem with the confession and they wouldn't go there. But that happened several times, actually.
I think our time is up.
Yes, yes, popping back in. So we are at time. I'm going to ask very kindly for the gyms to hang out for a few extra minutes in case there are questions that folks have. The webinar has been recorded. We will be putting that up on the YouTube page for the Quattrone Center. I'll also send it out to everyone as a link with the slide deck attached. So you'll have, thanks Jim, access to all the resources that are here, as well as the sample timelines that Detective Trainum put out and the other materials that have been covered. So for those who've joined in, thanks very much for being with us. And as I said, we will let you know about next month's webinar as soon as we possibly can. So if folks want to hang on, please do. Everybody else, thanks for coming in.
And thanks for plugging my book. I didn't